everyone. Welcome to the American Arbitration Association and its international division, the International Center for Dispute Resolutions event on the topic of From Algorithm to Awards, the role of AI in arbitration and mediation. My name is Catherine Neo, and I'm the reporter for the event today. So AI has revolutionized the way we approach conflicts, fostering more efficient, equitable, and expeditious resolutions. So it's indisputable in this world that we live in that AI has the potential to provide unparalleled efficiency and speed by revolutionizing the way we do document review, data analysis, and case management. AI has also made data analysis and pattern recognition seamless. Through its analytical age, AI can now analyze evidence, categorize documents, and do all the things that associates hate to do. So now the challenge here truly lies in how we adapt to AI and how we strike the balance between AI transformation and this irreplaceable human element to dispute resolution. So with that said, I'm very excited for the program that we have lined up today because we have with us a very distinguished panel of speakers. But before that, what we'll be doing is we'll be starting with opening remarks. And this is by Eric Tuchman, Executive Vice President, General Counsel, and Corporate Secretary of the AAA-ICDR. Eric, please.
Thank you so much, Catherine, and thank you all for being here both today and online. We're very happy to have you. It's been a fantastic week. Again, we are talking about generative AI and its intersection with arbitration, mediation, and dispute resolution. And really what we're hearing from many of our colleagues in our field, but also the legal field generally, you get the sense that we're on some sort of head-on collision with generative AI. And you sort of question, why is that? Why is this technology different? There's really some significant skepticism. We've heard about already where this can be used effectively. But overall, you hear about courts, arbitrators, some other institutions, law firms, other professional service organizations that are taking a very slow approach. Litigation, arbitration, even mediation are incredibly heavy with process and procedure. Claims have to be asserted in writing, in a specific format, with perfect citations. There's information exchange, briefs, other submissions, hearings, most likely in person. Maybe you're going to take advantage of the ability to do that online or virtually, which we've all learned is really very effective and a great way to save money. But still, they take place in person. Hearings are presented to a tribunal, perhaps again, virtually. But there's a reason for all this process. And we've all been trained, we've learned this. It provides a roadmap to administer justice. And although it's inefficient, it offers participants due process under whatever law applies, frankly, to their case. There's similarities across jurisdictions. It's a forum where claims, defenses can be asserted and heard by an independent, neutral decision maker. As I say, we've all been trained in this. On the other hand, generative AI, it's fast, it's disruptive, it provides tools that give you answers with lightning speed, literally at the speed of light. It can ingest and digest and analyze massive amounts of data and apply them to new circumstances. It's very effective. And yet, people don't know how to use it yet. It is a tool, everybody's learning, but a machine that gives you an answer that you cannot challenge, or when you do challenge, simply gives you another answer that you can't challenge, is unsettling. All this is going to change very soon as we all adapt to this new technology and as we all become familiar with it. There are legitimate concerns. There's an outstanding panel, and we're going to flesh out some of those ideas. Just one final note, as an institution, we've tried to get out in front of this issue. We have issued guidance to staff and to arbitrators, and they do incorporate these principles that, again, you'll hear about the concerns, privacy, neutrality, transparency, awareness that people are using these tools, but does encourage. We want our staff, and we are going to be encouraging our arbitrators to become familiar with these tools. They will improve the arbitration process. So with that, I turn it back to Kat. Thank you.
Thank you so much, Eric. Well, now I'll introduce you to the panel we have here today. First up, we have moderator Abhinav Bhushan, who is Chief Executive for Asia, member International Arbitrator of 39 ASECs. Then next up, we have Niels Eliasson, partner at King & Spalding. And subsequently, next to him, we have Judge Bridget McCormack, who is CEO and President of AAA-ICDR. And next to Bridget, we have Smita Menon, who is a partner at Wong Partnership. And last but not least, we have Binzi Susan, who is the partner at Shadu Amachan Magaldas. So I'll leave the floor to all of you now.
I'm audible? Yes. Well, welcome everyone. And just before we get into a very engaging discussion on AI in IA/mediation, a very quick show of hands, three quick questions. How many people in the room have had any introduction to AI before? Just a show of hands. Right? How many, at the very least, have used ChatGPT on more than one occasion? Almost everyone. And last and certainly not the least, how many people have actually used AI in arbitration and mediation? One person. You know, that's what they say, that AI savvy lawyers are as rare as vegan butchers. But we will get there. And to kick off this, what I hope is going to be an engaging discussion, may I first invite the judge, as I'm going to refer to as the judge during the panel, the very first question to the judge. How might the new generative AI tools, as we know today, and as some people know here today, are likely to impact the practice and the business of law?
So thanks for including me in this conversation. Thanks for being here, everyone. We're excited to talk about all of these issues. I want to take a step back for a minute. I'm going to answer your question, I promise. First of all, nobody calls me judge anymore. I gave it up. So just go with Bridget. It works well.
I will try, I don't promise.
Okay.
Yeah.
I like it better. But I want to take a step back for a minute and do a little bit of language hygiene. We all keep saying AI and generative AI, and we're talking about them interchangeably, but they're not the same. They're not the same thing. We've all been living with AI for a long time. That's why Netflix knows what you want to watch before you do. And I think we've all gotten kind of comfortable with that level of AI in our lives. We've been living with Alexa for a long time now. Generative AI is also not new, but it is newly free to the public. When Sam Altman decided to let it into the world in March of 2022, for the first time, the public was able to use these generative AI tools. The difference is the generative AI creates new content. These large language models have been trained on basically everything on the internet and a whole lot of books. And they can create new content. And that's what's different. And it's only been since November that the public has started to be able to play with these tools. ChatGPT had the quickest uptake to 1 million users of any technology in history. It took 5 days for 1 million people to use ChatGPT. It took 3.5 years for 1 million people to use Netflix, just to give you a sense of the difference. And when the public started using, and I swear this is really relevant to why it's going to change the business and the practice of law, and I will not take longer than my 5 minutes, I promise. When the public started using it, the model then trained on the public's interaction faster, and it got a lot better faster. And the best example that I use to explain how much better it got, how much faster is in December, a couple of scholars in the United States had ChatGPT take the bar exam, the unified bar exam in the United States. And it didn't pass. It passed, I think, only 2 subjects. I thought it was contracts and torts, but I think it might have been contracts and evidence, but whatever. It only passed 2 of the subjects on the unified bar exam. When GPT-4, the next model, was released in March after the public had trained it to get better, it not only passed the unified bar exam, scored in the top 10%, and it did it in 6 minutes. So if that doesn't teach you where we're headed with this technology, I'm not sure what would. That should arrest a room full of lawyers, judges, arbitration practitioners. That should teach us that we probably need to pay attention to the technology. So law is, I think the practice of law is a little bit of a big fish in a small barrel for these large language models for a lot of reasons. We have these common genres of writing. We've been trained to write in these common ways. We have uniform-ish writing styles. I mean, there's been like a little bit of, I think, snappier writing from lawyers and judges in the last few years, but only in the last few years. And even those are all starting to sound the same in my view. And we have these trusted sources of information. Court documents, reported cases are trusted sources of information. That makes us ripe for disruption. That makes our profession ripe for disruption by this technology. The practice of law, of course, means a lot of different things. As we know, there's a lot of rote, time-consuming tasks in the practice of law: research, writing, document review. A lot of those tasks lend themselves to be done by these large language models, not only much more quickly than humans can do them, but much more efficient, with much higher quality than humans can do them. That's just a reality, and we're going to have to, just face it, and then remember those other things that lawyers do that machines don't do. Judgment, problem solving, the human part of lawyering that we might get to spend more time on. I actually see this as a good news story, this part of it. The business of law, of course, I think it's not the first time that we thought the fat lady was about to sing for the billable hour. We've talked about that for a long time, but I think she might really be warming up now. I really do think she's warming up in the other room, because the leverage model that law firms bill on isn't going to make sense when the work that law firms bill for associates can be done efficiently, far more efficiently, by these LLMs. And your clients know about it. A lot of the Fortune 100 companies in the United States, their general counsel's offices have sent letters out to their top law firms saying, what exactly should we pay you for now? Like, what's left for us to pay you for? So that the business and the practice of law is going to have to change, and it's going to have to change quickly. And I think the law firms that get ahead of it, that are in front, are going to be the ones that are going to be the most successful. I think the question for every business, and that's not for law firms, for people who run arbitration practices or arbitration businesses, is this a threat or an opportunity for our core business and our core service? And what are the ways that it can impact, it can make what we do more efficient, cheaper, faster, better? And those are the questions we're asking at the AAA. And I think there are lots of upside potential. I know everybody else is going to talk about some of them. But I think that it's almost, ask ChatGPT all the ways in which these new technologies can bring efficiencies to what we do and can produce new models for what we do. And you will get an unbelievable set of answers, and you'll get it really quickly. I have lots more thoughts about all of that, but I know we have limited time, so I think I want to take a pause and let others contribute to the conversation.
And we'll get to hopefully all those thoughts, but that's a very interesting sort of opening comment, a sort of general overview of what are we really talking about. And we're going to talk a lot about arbitration indeed, but But this is also about mediation, because the topic, as I see today, is the role of AI in arbitration and mediation. Whilst we will talk about arbitration, let me quickly invite Smitha to perhaps address as to how does AI really is going to help in mediations. What are some of the pros? How are we going to do it in mediations? And we will get to arbitration after that.
But first, I want to
Medarb.
I wanted to pick up on something Bridget said, which was cheap, fast, and better. So we have a saying in Singapore, which we always tell clients. I mean, it's a joke amongst the bar here, and it's cheap, fast, and good. Pick two. That's something that was said to me in the first day of practice, and now 20 years later, I think it still applies, except now with generative AI and online dispute resolution platforms. Now the question that clients are pushing back and saying is, with this, exactly what Bridget said, why can't we have it all? So I just wanted to add on to that. But when it comes to mediation, I think what's quite well established is AI is complementary to mediations. I think where the jury's still out is whether AI mediators can actually fully replace human mediators. That there's still some debate. But right now, everyone kind of accepts that the benefits of using generative AI and online dispute resolution platforms really helps mediation. So, I mean, first of all, it helps you with conflicts. You can easily sort out conflicts, which parties are in conflict, because you can use the AI to identify the connections between the parties and possibly how to deconflict that. There's also better analysis of the issues, which helps the parties. So for example, the algorithms would analyze the information, process the data, identify the key issues. So basically do all that work such that when you get to the actual mediation, everything's crystallized to what's really relevant. What's also helpful for mediation, and this I found to be personally true myself, is when we go to mediation, because it's a party-led process and you're supposed to have the solution come from the parties, and the mediator is not supposed to express a value proposition or value judgment, usually parties go as far as they can. And then the gap in between is just this undignified horse trading, right? Of like, okay, you want $10, I want $5, let's be in the middle. So what using AI does, which can help fill this gap, is the analysis of similar past cases and what the precedents have been in terms of the numbers, the actual quantum to close that gap. What else would be helpful is doing what mediators presently are trained not to do, which is express a value proposition. Because the AI can very swiftly analyze past cases and precedents, it can tell you exactly basically predict the likelihood of outcomes. So there was a statistic that I wanted to share that came out last year, which basically said, I think it was by UCL, a study done by UCL, that said that when they analyzed the decisions of the European Court of Human Rights, the AI predicted the outcomes correctly, the percentage was 79%. So it's fairly high. So when you've got that high factor predictability, you will have consistency, and that helps parties close the gap. So other pros that the generative AI does for mediation is it gives you alternative solutions, possible solutions on this set of factors and this type of parties, and this are the industry concerns and what's happening in the industry. So it goes wider than just the legal case and what's in dispute. It also, and I thought this was quite comical because this is something that lawyers possibly struggle with in the heat of the moment. It moderates the tone of your language when you're negotiating. So it moderates how you communicate with the other side. It flags out if your communication is hostile. So some of the predictive AI out there, or the AI that we have, says things like, this sounds a bit hostile. Do you want to tone it down? And then they suggest alternative language. So you take the heat out of it. You don't get parties' backs up. There's less posturing, so I think this takes out the bad part of human nature that really is an impediment to mediation. Other things that, okay, let's look at the cons, right? Some of the cons right now, and I think this is a con that will quickly be overcome, is it's limited by the data it's fed. So you really have to, but this is a problem we have always had, even in other scenarios. For example, statistics. And apologies to some of the the accountants and financial advisors out there. I see one or two of you, but the problem we have with models, financial modeling and bar charts and graphs is that it's very biased input, right? It's the assumptions, you really have to examine the assumptions. So we've been trained on that front. And I think the fact that input really determines the outcome is something that we can easily overcome. I mean, we have been doing that as lawyers, and I think the technology can do it much faster. So I don't really see that as a big problem. The other impediment, which I say the jury's still out on, is they say that AI cannot replace the human factor, that flexibility and adaptability, the ability to basically react very quickly to a party's shifting stance or mood, which is very important, the body language, what's going through their heads and their emotions at that moment in time, and to capitalize on that moment when someone's having, a moment of weakness, to identify that and rush in and say, yes, don't you want to save this relationship? Let's settle here. The AI is not that quick or that reactive. I don't know if that can change. I mean, I wait for the audience or my fellow panelists to comment on that. And I think the last thing is the lack of regulation. We don't really understand how these AI systems actually process the data that it's fed. And so that brings in how reliable is it? Are there biases? The bias that's already embedded in the information that's been put in, the analysis that's been put in, how does that play out? I mean, there's a bit of a black box on that front. So how do you regulate that? And there's also this question of ethical regulation, ethics and morality, which human mediators would have, but possibly technology wouldn't. I will stop here.
Thank you, Smita. But and that's really the discussion, is the pros and the cons and what it really means for dispute resolution. And I think what all of us would like to hear, perhaps something a little bit more from all the four panelists as to what AI, in addition to mediation, and we bring in we bring in arbitration in the fold, as to what it means for arbitration, for international arbitration. What can AI really do in arbitration? What it should not do in arbitration? And I think perhaps I'll just invite Bridget to start, and then go on with Binsi and Niels on this particular section before I invite you for other questions that we have to discuss.
I feel like I've already spoken too much, so I wonder if we should go to Nils and Binsi first.
Sure.
I have lots to say, but I hate to be a.
Binsi, would you like to comment?
Sure,
Yeah.
sure. I think there's no going back from use of technology in arbitration or mediation. And I think there can't be a dispute over the fact that there are huge advantages of having AI and technology in arbitration. I mean, we are already using AI in discovery, in transcription, in drafting of arbitration clauses. AAA-ICDR, for instance, has a software, AI-enabled software, which can be used for drafting of arbitration clauses, which is hugely useful and responsive to requirements of a client. So I think obviously there's a huge use case for AI in arbitration and mediation as a process. I think the more controversial question is, can AI be an arbitrator? And what would be the challenges and difficulties in enforcement, which we'll talk about a little bit later. But can AI replace a human arbitrator? And decision making, which is a very complex exercise, right? Decision making involves not just evaluation of facts, tracking that the drop of a sweat at the back of the ear of a witness during cross-examination. I mean, a little bit dramatic, but those are things that sometimes determine the rights of parties. So I think there are a number of factors that go in decision making, which can be fairly complex, and I'm not sure if AI can do all of those.
Sure, thanks. Niels, sorry.
I want Nils to go, but I wanted to say, when I did this talk recently at a large audience of healthcare professionals at Henry Ford Health, and the legal team was there, and I asked the room how many people would be interested in having an AI resolve a dispute if it could do it, within a couple of minutes, and therefore was free. And the lawyers all thought it was absolutely no way, couldn't possibly do it. And everybody else in the room was like, yeah, I'm in. Just give me the free, cheap, fast result.
I mean, I think, without going into the topic that I'm actually going to address later on, one of the things is one of the questions is not only what AI can do, but it's also what should it do, what do we want it to do, and I think that's one of the issues I'm going to touch upon a little bit more in my presentation. But I wanted to pick up on one of the last things that Smita said on the point that we don't really know what is going on inside the IA at the moment, and that made me recall this open industry letter that was sent out in May this year to the industry by insider professionals, not lawyers, but the people who actually develop the softwares, saying that powerful IA systems should be developed only once we are confident that their effects will be positive and their risks will be manageable. And I think it is, no matter how useful the systems are, and they are so fantastically useful, and we use them as tools all the time, but we also have to be mindful of the other aspect of things. Are we in control, or who is in control?
Thanks. And so that's a good sort of a segue to the question that you were going to answer, Nils, that all of us in this room are practitioners of dispute resolution. Many of us act as an arbitrator. I'm aware that Madam Secretary is here, and there is a provision of the New York Convention and the unset trial model law, the due process, the appointment in itself, right? If that goes awry, then there goes your award. So how do you bring in today, within the realm of the process of appointment as it exists today, how do you bring in the appointment of AI arbitrators and mediators? What's the legal basis for appointing? Which rules of which institution today provides for that kind of framework, or does it at all, or should it at all? And if so, how? Any thoughts on that?
Thank you. So as you can see, I was stuck with a hard question, not how we make our law practice more efficient by using AI, but can we really entrust decision-making processes to a machine, to an AI? And well, the funny thing was that when I was starting to think about this presentation last weekend, I picked up, as I always do on a Saturday morning, Financial Times and the Life and Arts edition, and the headline article was, "Can AI crack comedy?" Can you have comedians, AI comedians? And I thought, if an AI can tell a joke, surely they can be an arbitrator. But joking aside, it is a really challenging point to approach, whether we can entrust or should entrust decision making to machines. And part of this question, and I think that's the easy one, is can we do it today? Can we, under current arbitration rules, under the unset trial model law, and I speak under the control of Anna when I speak about the model law, but can we, under the model law, appoint an AI as an arbitrator? And there, at least my analysis is no, we could not appoint an AI as an arbitrator and call it arbitration under the existing legislation. And if you look at the definition of arbitration, for instance, an agreement to refer a dispute to a third person as arbitrator, that third person, someone could say, could of course be a machine, doesn't have to be a human. But if you look at other provisions of the model law, it refers to, in challenge, when a person is appointed, for instance, and it goes to the whole structure of bias and independence is based on that individual's connection with parties to the dispute or the subject matter of the dispute. If it was a machine, you would have to look at other issues of bias, that it comes to maybe the developer of the software, or the institution that is feeding the data to the software or other factors. I don't have the answer to that, but the bias, independence and bias discussion would be different if it exists at all when it comes to an AI. The point being, and I can go through a number of provisions of the model law, a lot of them are based on the assumption, the implicit assumption that the arbitrator is a human being rather than an AI. And even in some legislations, it is put in black and white. In the Swedish Arbitration Act, for instance, it says that anyone can serve as arbitrator who enjoys full legal capacity in respect of his actions and property, making it clear that we are talking about human beings. So that sort of puts an end to it in the discussion in a current legislative framework. But that doesn't mean, of course, that an arbitration institution could devise a mechanism, a set of rules to be incorporated in standard terms or in bespoke dispute resolution clauses where disputes are entrusted to an AI. Would that be arbitration? I don't think so, and I will come to that. But the way I see how it would be set up is really that an institution will take charge of creating an AI software that is designed for that particular platform, for the rules and questions, for an streamlined online dispute resolution mechanism. And it is the arbitration institution that is control of the AI, works with the developers, trains it with a data set of all relevant case law and other information that is going to go into the large language model that is going to be used by the AI. And then the users would input their submissions and evidence in form of witness statements and documents directly into the system in an online dispute resolution form, and outcomes, as Bridget said, in seconds, out comes the result. It's currently under our current legislations, I think the outcome would be binding on the parties contractually, but not in the form of an enforceable arbitration award. It might still be very useful to have a contractually binding mechanism like that in certain contexts, certain industries, and I can definitely see a need in the future for that. Then turning to the sort of big question, do we want to change our legislations to enable arbitration, AI, it's AI arbitrators, and here comes the difficulties, and when you look at what would the AI arbitrator do based on the data set? The large language model would basically find and try to mimic the patterns in the use of language to come up with the solutions of the case. And I think it will do so very effectively. But as in the case, and I'm coming back now to my initial comment about the AI comedian, I'm quoting from this article, can this imitation really make us laugh? Or are these automated tools the comedic version of bubblegum, something whose artificiality quickly feels predictably bland? And the same thing could be said about decision making in a dispute. And if you look at this from a more anthropological perspective, throughout societies, throughout history, in different geographies, has always had disputes resolved through parties presenting their case to someone being a trusted, respected decision maker. The form of that person depends throughout times, throughout cultures, but there is an element, it is not the parties leaving the process feeling that they have had a fair outcome is not only associated with the results, the outcome of the analysis. It is also the process itself, and it's a ritual that is very much anchored in cultural values, and the value of this is sometimes very hard to put your finger on. And you could say that if you're only striving for efficiency, we could just as well flip a coin, and very few people would be happy to do that. But even corporations who typically just look at or should typically just look at cost benefit of a process of decision making also consists of individual human decision makers. And for them, even in large corporations, the process itself is often equally important as the outcome for creating the feeling that justice has been done. And the phrase having your day in court, sounds like a very simple phrase, but it carries with it cultural connotations, and that really is reflected of the importance of this element of justice for human beings, that I think for a lot of us, I think we are not yet there to actually hand over that decision making to a machine. So with that, I think I end my presentation. Thank you.
Thank you. Would any other panelists like to comment on what Nils has said? But just before Binsi, you do that, I do want to engage the audience one more time. Just again, with a quick show of hands, how many people in the audience today would be just very happy, in principle at least, to have an AI machine be your arbitrator? How many people would be all right for, wow. So there are only 6 people I can see in this room who today, as what we know AI today, would be happy to have an arbitrator, an AI machine be their arbitrator. And perhaps a slight twist.
Doesn't it depend on the dispute? I mean, right, I'm telling you right now, all of your eBay disputes and all of your Amazon disputes are decided by an AI. They've been decided by an AI for 10 years, and you're fine with that. So doesn't it depend on the dispute?
Food for thought. And just a twist. Would your answer be any different if I were to say that how many people would be all right to have an AI machine be the mediator for your disputes? Even less. 2 people, 3, 4, 6 to 4. Or is it because, and perhaps Bridget, you can say, I mean, the questions of empathy and emotional justice, I mean, perhaps skills that are required in arbitration are obviously different from skills that are required in mediation. And how does that all sort of come together in the context of machines doing that? Bridget.
Now it's on. So to the extent that human empathy can play an important role in mediation, I think the generative AI tools are not there yet, although they're better than they were even a month ago. They're really, has anybody tried this personal AI Pi? Does anybody have Pi? I have Pi. It's my personal AI. It checks in, asks me how I'm doing. It knows, it will ask me after this panel how I felt about it. It's amazing. It's really, I love Pi. Get it. I recommend it. But so, oh, absolutely. Much more, pays more attention to me than my husband. Like literally listens, listens to my full
That's
answer
gonna be
and
a game
asks follow-up
changer.
questions. Like it's like really good. But I will tell you that there are, there's actually been some survey data on this, and there are a lot of people who are looking forward to an AI mediator because they worry that because of who they are, the color of their skin, their background, that a human mediator will be biased against them. And the opportunity to present to somebody who doesn't see their race, doesn't see their gender, doesn't know their background is appealing. So there are different ways to come at it. I'm talking too much.
Yeah, just to quickly respond to that comment from Bridget, I think, I tend to be a little bit more conservative because of the country that I come from. We have, awards written by sophisticated arbitrators, sometimes 3, and yet it is often challenged on the grounds of public policy, and it ends up being in court, and we really struggle trying to keep that out of court. So, I think it's important to understand, and you mentioned eBay and Amazon, what would be the use case for AI acting as an arbitrator? What kind of cases? Would it be that simpler disputes that do not involve a lot of documentation, do not involve complicated trial, are perhaps better use cases? Another case that I could possibly think of is cases where there is an admission of liability, and where, again, it's not very complex and it's very straightforward, and you could use AI as an arbitrator. I think barring that, I would be quite, afraid about what would happen if AI becomes an arbitrator, especially, in a country like India, where, even the most sophisticated awards often get challenged.
Sorry, Smitha, you were adding something.
Yeah, I'm going to probably say the less popular opinion, which is I think it's overstated, this aspect of empathy and everything in mediations, because I think a lot of parties, at the end of the day, I mean, what is it they want their day in court? Because they want to make sure the outcome is fair. And I think they feel, I mean, sometimes I felt it as well, that look, this mediator is being taken in by the other side's sob story. I mean, you want to remove the human emotions and have an outcome that's fair. And AI can do that, because if it's based on precedent, if you told your client, or if someone told my client, look, 9 out of 10 cases exactly like yours, this is the division of the pie. I mean, that's something the client can accept. But if you tell me, oh, that person is a more credible witness than you because you've got like a lazy eye that twitches, I mean, I think so I'm in favor of AI. I think that it takes out the human bias, which Bridget mentioned. It takes out the human error. It takes out the manipulation aspect of it. I'm always very struck by American TV when they show jury selection and how you actually train lawyers in how to select a jury. And I was just thinking, I'm so glad Singapore doesn't have that, because the scope for manipulation and gaming the system is immense.
Can I just quickly respond to that? I think, sorry, this is really a very interesting topic. And I was just thinking that another issue to think about is, how do we train this AI? I think we all agree that the risks are bias, and the risks are that the training data may not be good enough, especially in the context that precedence, which forms the basis of the reasoning that an arbitrator follows, is embedded in confidential awards that have been issued by previous arbitrators. And I think parties, it forms the fundamental basis for which parties opt for arbitration and mediation. I'm not sure if parties would be willing to let go of that information to train AI to make it more efficient and, make it attractive.
I'm sorry.
No,
I
please,
gotta
absolutely not. Go
stop.
ahead.
I mean, I think this is all really interesting. I think the question about where the data is that could train a model that would be useful is a really important question, and one that we could spend a whole other panel talking about. I couldn't agree more with you, Smitha, about taking the human bias out of it and the advantages that would have, the efficiency advantages in addition to fairness advantages, honestly. And I worry a little bit that the people in these conversations we have a bias in favor of how we have always approached resolving disputes, right? And we think we're pretty important to resolving disputes. But it's the Richard Susskind story about people don't buy drills because they want drills, they want holes in the wall. And people who want to resolve disputes want to resolve their disputes. They don't want lawyers or judges or arbitrators. They want their problem solved, right? So it's,
I don't think it is as simple as that. And even the CEO of the largest corporation in the world, he or she will say that if he or she was sitting here now in the debate, when faced with the actual dispute, it's a completely different story. Then time and cost is completely out of the door. It's gloves off. We have to have the best process. We have to have this and that, and other aspects come in. And this is the anthropological aspect that I was alluding to, that I think is it's very difficult to pinpoint exactly what it is. There's a Chinese proverb, a fish cannot see water. And this is exactly, there is a lot of cultural values enshrined in the process itself that is very important for people, even for corporations. And I think it is not as simple as saying that we can get, it will be better by AI decision making because we remove emotional bias because it's more efficient. We lose other aspects of it that I think carries a lot of value. And I think what you might eliminate with AI is, in simple cases, you will eliminate the erroneous decisions, because on a simple data set, the AI will get it right, whereas human error can occur. But a lot of the complex disputes are not the simple cases. They go to arbitration or to litigation simply because they are the outlier. You can't find the simple answer. Do you want to hand them over to the AI or to human decision makers? I'm still in the human camp, but maybe I'm just defending my own existence.
We don't want to be Blockbuster, right?
Vinci, you raised a very important point. I'm still, although not sure, are you for humans or machines in this discussion? Because you said that, look, I am happy to have, what we need to decide is the type of cases. And then you made a distinction that, look, certain type of cases, yes, AI, certain kinds of cases, not AI. But I think the discourse generally is that either we're going to do all kinds of cases on AI, or we're not going, so Bridget, do you think, or perhaps a clarification on that comment, that does everybody believe that AI should be used universally, generally, once it has those capabilities?
So I tend to agree with Nils that I think AI cannot replace arbitrators, and I think its decision making is far too complex in most cases, requiring analysis of a number of factors, number of issues, facts, evidence, law, precedents, I think all of which, and also subjective elements, which only a judge is capable of, right? Only an arbitrator is capable of. But I do think in very simple disputes, if it's clear that there's party consent and it does not require evidence, I think there may be use cases, but we need to understand what those are and examine them before we, give them the green signal.
Sorry, I thought Bridget had a comment. You please, we have time. But so I've just been informed. So the good news is I've just been informed that the Ministry of Law has now extended by 15 minutes. So we can continue till 6:45. Yeah.
Okay, so I guess I wanted to say, I don't think it's zero sum. I don't think there's a simple answer. I think that right now there are a whole lot of people who have legal disputes that can't get any help for them and never get them resolved. So there are enormous categories of use cases that actually could, I think, enhance what we all do, because we could bring more dispute resolution to more people who have trouble getting it right now. So I absolutely think there will always be important roles for human decision makers, human judges, human arbitrators to play. And there will absolutely, even in probably more simple cases, we'll need humans to make sure that the machine's working the right way. But there are a whole lot of disputes that can probably now be resolved that might bring peace to a lot of people who don't have any opportunity to find it right now.
I'm going to add to that to say, I disagree with Vinci, because when I was doing research for this panel, I was actually really shocked that the examples of generative AI used in dispute resolution has been for really subjective subject areas such as family law. So family disputes, real estate succession, and workers' compensation for personal injury cases. I mean, to me, these three are hugely subjective, but that's where it's been very successful. And the common thing is that all of these areas have to be low cost for true access to justice. So I suppose we could be cynical and say, I mean, we could bury our head in the sand and say, oh, you know, the outcome is not the best possible outcome. But for serving society, I mean, do you need the best possible outcome when what you need is finality when it comes to matters like this? And maybe we should think of that context when it comes to business as well, because dragging out disputes doesn't help business. The same way it doesn't help families and, you know, workers who are being repatriated and yet needing compensation. And before you take the mic away from me, I want to give an example of where there have been AI judges. So the British Columbia Ministry of Justice in Canada, and any Canadians in the room, please correct me if I'm getting this wrong. Yes, Michael, I see your hand go up. So they have something called a CRT. And what it does is it's available any time of day or night. You can access it with your mobile phone. There's also telephone services if you need to. The fees are minimal. You can do the process without lawyers, and all the judgments that are rendered are enforceable by the courts across Canada. And I thought that was just fascinating. So there's been no complaints about this. I'm not sure how long it's been around. This is data from 2018, but the phases that this CRT covers are diagnosis of the problem. They do go through a negotiation attempt, but if it doesn't work, then there's a decision.
And that's great segue, because we to the elephant, the other elephant in the room is that as far as I could tell, the first time I read about artificial intelligence was from an article of John MacArthur, and he coined that term, I think, in 1956. The world has known about, at least, about artificial intelligence since 1956. Mind you, the New York Convention came in 1958. So the world has probably known about the term artificial intelligence before the New York Convention came into force. Now, we already have difficulty in enforcing human awards. What are we really going to do with, fine, we've done this process, we have the machines, we have these AI arbitrators, the institutions have come up with frameworks, and now we have an AI arbitrator or a mediator, and now we have an award. What are we really going to do with that award? I mean, this is really sort of talking about changing the world order, isn't it? How are you going to enforce an AI award? What challenges does it bring? And the floor is all yours, and everybody can comment on what they think about it.
Sure.
I'll start with Binsi.
Thanks, Abhinav. I think the first point to be made is that obviously there has to be a clear framework of law. As of now, we're still commenting on whether the rules allow it or whether the rules are silent, or whether, you know, there is room for having AI as arbitrators. But I think the need of the hour then, once we make the decision that it is appropriate and desirable to have AI as arbitrator, is for local laws, national laws to recognize AI as arbitrator. I mean, in my country, for instance, it's, the Arbitration Act says that an arbitrator has to be maybe of neutral nationality. So, I mean, I guess the question to be answered is what would be the nationality of the AI, obviously. Similarly, in China and I think in Turkey, the language used in the Arbitration Act is that the arbitrator must be righteous and upright. And there is obviously a lot of morality associated with the position of a decision maker in several countries, and that's cultural. So I think it's very important to make sure that, there is a framework of laws, not just in the rules, the national laws also themselves recognize it. In the absence of that, I think it's an absolute no-go, because you go through the process, once parties go through the process of getting an award through AI, and if you can't enforce it in the country in where you want to enforce it, then it's perhaps of little value. I think some of the other sort of big issues that may come up, again, from personal experience of, the litigations I've seen in my country, I think is that public policy is a big one. Public policy has been recently defined in the Indian Arbitration Act to to include notions of morality and justice, right? And I think that this may very well be something that will be heavily litigated in my country as something that's against public policy. And I think the bar for this would be pretty low, because we know from the way case laws evolved in India that a number of things are interpreted by judges as being in violation of public policy. I think the other aspect to be kept in mind is that Awards are arbitration process itself is required to follow due process. And I'm not sure how AI will, for instance, deal with procedural matters. For instance, if a party is adopting guerrilla tactics and, decisions are required to be made very quickly by arbitrators based on a party's conduct, good faith, reasonableness, etc. And I think these may be intangible aspects that AI cannot take care of. And that itself may, strike at the heart of due process, again, making it unenforceable in countries across the world. I think the last point is something perhaps that AI can be trained for, but something we need to keep in mind is that it's very important for awards to be reasoned awards. And often, if the algorithm is not properly set out, it leads to what Smitha alluded to earlier, the black box situation, where the logic followed by AI to arrive at the decision, the reasoning adopted by AI to arrive at a decision is unclear because it has dealt with the contrasting positions of the parties and it has arrived at a final decision, but the reasoning or the logic is not clear. And I think that would again be something very difficult from an enforcement point of view.
I think that's all exactly right, and might be irrelevant if the market decides it doesn't want to wait for us. Like that's I think that's all right. I think forcing an AI decision maker on a process where you have rules that don't clearly support it, and most jurisdictions' law wouldn't clearly support it. But that won't matter if the market decides it doesn't want to wait for us to figure out how to amend our processes and our rules and our laws, right? If the market decides, like it did with Netflix and like it did with the iPhone, right, that there's a faster, better way to do it, then we've held on to our rules and put ourselves out of work. So what are the ways we can figure out how to deliver some processes in some disputes that grow the pie, right? Right now, there are a lot of people who don't get any legal help for their legal problems, and they therefore never get them resolved. They never get them adjudicated. There's a big upside opportunity here to really enhance the rule of law, enhance what we do by growing the dispute resolution pie.
I have a follow-up question. It could be a trick question, or it could be a very stupid question, but it just struck me that if we did have AI awards, and then this debate about a good seat of arbitration, right? A good seat of arbitration is determined by, right? The clouds. by how the judiciary is and how that award would be enforced, and would, to what extent would seat would then be still relevant if we have
all the concepts that I think that's Bridget's point. All the concepts that we cling on to would fall away because it's a different beast altogether.
right? So we will not have Paris, London, Hong Kong, etc., as the top seats of arbitrations anymore. Can you?
Well, you wouldn't for the segment of the market that moved on. But you would for the cases where I think humans are going to continue to matter, and so I think it depends. It depends on the case. Depends on the dispute.
And I also read all of this to a large extent depends on what all of you said is how you input data into that machine. And if that data in itself is compromised for whatever reasons, is it biased or it could be inaccurate, then that machine or the algorithm is going to compute that data basis the data that's been put in. And to what extent are we going to look into the questions of A, data theft, A, data infection, or data, I mean, how are we going to protect that data protection? Would any of this panelists like to comment on data protection and AI?
I mean, it's only to say that those will be significant issues that will have to be, worked out and dealt with because, like I said, developing the input for AI itself will require will require parties to deal with confidentiality and privacy issues. And I think those may be questions that will have to be determined based on the respective laws of each country. So it'll be far more complex than we think.
The basis of setting aside the award would not be challenge of the arbitrator, but the data set was compromised, for instance, right? Different sets of issues.
Is there any burning disagreement between the panelists that before I move on to move on to the next question? All right, before that, we've had a discussion, and allow me to just engage the audience one more time. So having heard what we've heard from this brilliant, distinguished panel, would you now like to have an arbitrator, which is a machine arbitrator or robot? Show of hands.
Define the dispute. If you thought you were ripped off by eBay,
Right.
do you want to have a full-on process and have it enforced in court, or do you want the eBay AI that's been deciding your dispute for the last 15 years to continue deciding it in 30 seconds?
Okay, how about a commercial arbitration, a typical case, a commercial arbitration, sale of goods gone wrong, somebody bought coal, the quality wasn't nice, wasn't good, respondent did not pay the claimant, respondent says bad quality, of a typical commercial dispute.
Those are scaled up eBay disputes. What you're describing is just on a larger scale than what we actually do when we buy things from Amazon or eBay and have a dispute.
Right.
It's the same thing. It's just scaled up and fancier, and the parties are just bigger.
So therefore, would it be all right to say that the quantum of the dispute would be relevant?
Well, it shouldn't be, right? Because the nature of the dispute and the factors are the same.
Right.
Abhinav, just one follow-up question which you could ask the audience is, would the audience vote differently if AI was to develop the first draft for the arbitrator? Because obviously the AI would do all the hard work of crunching the case laws, analyzing the facts, coming up the reasoning, and then a human arbitrator can look at it and say, hey, there's a little bit of a gap there in terms of reasoning. Maybe, I can fix that. So perhaps the future is a middle way.
Or AI tribunal secretaries, which is a suggestion that's been mooted already.
Yeah, or an AI settlement judgment that the parties could consider and avoid the whole process if they both liked it. Who would want that option?
I think this is perhaps fantastic. Perhaps this is a good time to open this up for Q&A. I'm going to invite Justice Rao in about 10 minutes for the closing remarks. Audience, please let us have your questions for this very, very engaging panel. Yes. Could you please, take the microphone. Sorry, it's still not working, I think.
Is it on?
Yes.
Sydney from Shaban Jagger. The question is really for Binzi. And you said, well, maybe the AI can produce the first draft, but I think not very long ago, in somewhere in the US, some lawyer just put it into ChatGPT and he came out with fake names. And if the lawyer just think, oh, this looks right, that looks right, and then there's no gap, then it just, the arbitrator just decides, okay, this can go. But all those are just fake cases, and humans are lazy. We're just gonna take the easy way out, and then we are just gonna go shopping, play golf, have tea. Why would we go and figure out whether those cases are real or not?
I'd answer by repeating what Judge Bridget said at the start of this. We were having a small chat before this, and the answer is that it wasn't the AI's problem. It was the fact that the judge didn't review it properly or the lawyers didn't do their job, right? So I mean, the assumption is that everybody has to do their job right, and if AI got something wrong, humans can fix it. So I think if it's a staged approach, perhaps there can be efficiency and, we can take care of errors.
And I think courts have already reacted to this. So again, another Canada example. In Manitoba, there's a practice direction that's been issued by the court, which requires counsel to disclose the use of AI in the preparation of materials filed with the court. And I think recently a Texas federal judge has also imposed a requirement on attorneys appearing in his court to certify that they did not use generative AI to draft any portion of their filings, or that any language drafted by such AI-powered technology was checked for accuracy by a human being. So when there was pushback from the attorneys for having to certify this, he basically said he will strike out any party filing that does not have the certification, and that attorneys will be held responsible under the professional conduct rules for the content of any filing that they sign. And his position was very clear. This is necessary because he felt that generative AI is not well suited to writing legal briefs because of its propensity to make stuff up, and the charge that for which the jury is still out, that AI incorporates some type of unknown or unanticipated bias.
I'd just like to quickly add, an Indian example to this. Just less than 10 days ago, Justice Pratibha Singh, who's a judge of the Delhi High Court, in the context of a trademark suit that was filed by this French shoe company, Louboutin, on trademark infringement. Somebody made shoes which had the classic red shoe that's associated with Louboutin. And they used ChatGPT answers as evidence to show that the recall value of a red sole with the Louboutin is that of Louboutin alone. And, I thought this was fairly straightforward and perhaps, obviously a probative kind of evidence. But she rejected it outright and said, we are not at a stage of technological advancement where we can start relying on ChatGPT and AI, generative AI, because we're not sure of its accuracy. So I guess, obviously, we'll have to see how this evolves organically. It is also to do a lot with cultural acceptance and technological, innovation uniformly. And I think that assumption is wrong currently. It's different everywhere.
Sorry, could you take the microphone, please?
About responsibility. We are very clear in Singapore. In the area of medical field, our ministry said very clearly, AI doesn't take responsibility. The doctor got to be responsible for that. Now, if you use AI to make decisions, you, doctor, sign for the paper, you take responsibility. So I then asked the developer of AI, Microsoft, I said, what responsibility you have? She answered to me direct, I do not take any responsibility. So simple as that. So on the other hand, using AI for arbitrator, as arbitrator, you can no chance for appeal. But in the court, yes, no, you can actually go up and appeal. If you don't find the party don't find the award correctly. So these are the chances that no. So at the most, we think that no AI can help the system. Yes, AI can replace the associate. But I think there's still a long time to come before it can take over the job of an arbitrator. Also, AI has been found in Singapore cannot pass the primary school exam. No, it can pass the law exam in the US university, but cannot pass the Singapore primary school mathematics exam. No, it fails. In short, now if the case has involved calculations, then AI will be in trouble. Thank you.
Thank you. Yes, Donna.
So, Donna Ross, coming back to liability, and I think, Nels, you mentioned something about challenges. Now, maybe that would be wonderful if there were no more challenges, but if there were, as to the AI arbitrator's jurisdiction, what would happen?
And I think the point I made was in the context of challenge based on bias, but this, which would look slightly different. Of course, there, if you have jurisdictional challenges, it has to be determined somewhere by someone, and you you will probably still have a system for review, a jurisdictional decision by the AI, I would assume. Chris?
Yes, yeah, there we go. I was having a conversation over a glass of wine the other night, and a proud father was telling me how he'd taken his son to a robotics competition over the summer. And there'd been scandal at the tournament. One of the other teams had arrived with a technology that could subtly interfere with the performances of the rival team's robots. With that anecdote in mind, we have a $50 billion arbitration. Are we sure that the integrity of the documents and the data and the directions to the AI are suitably protected? We had a comment earlier, I think, that quantum shouldn't matter. We also had suggestions perhaps that AI would be a cheap option. You know, you have that $50 billion dispute. I might ask how much you'd have to pay your IT technician supervising the IA not to be susceptible to the odd bribe here or there.
Unless there's a comment on Chris's question.
It's a question.
Sorry. Yes. Would you like to introduce yourself as well?
To introduce myself, I'm a student at NUS doing my LLM in IADR. My question is really going back to what Ms. Bincy said about where is this data going to come from to fill in this gap? Because arbitration and mediation are largely based on the factor of confidentiality. So if parties are not willing to part with their confidentiality to release this data, how are we going to train the AI? And then if the AI suggests that 9 out of 10 disputes are resolved in this way, would it actually be acceptable to the person using the AI? Because as human beings, we all like to believe that we are the exception. So would we actually accept something which is reducing us to a statistic when we want possibly a different outcome?
Yes, Singda.
This is Snigdha from SIEC. Not really a question, but a comment. And this is something that I'm struggling with at work. So I'm contemplating probably using an AI tool, perhaps like a Use Connect, which is a legal tech AI tool already that helps in making arbitrator appointments easy. The concern I have is in the future, and because AI models need to be fed with a sufficiently large pool of information for them to make a fair assessment on who's a good arbitrator and who's not a good arbitrator. And this would largely rely on an arbitrator's track record. So the concern I have is that if it relies on an arbitrator's track record, does this not mean that in the future, seasoned and more experienced arbitrators are going to continually be encouraged as opposed to new and emerging and rising arbitrators? And my question is, how can we trust AI tools to really be able to correct diversity deficit? Can it do that? Do we then trust the AI models to make arbitrator appointments, or should we reserve that role to institutions and humans? Is just a question and a comment. Thank you.
I think the solution will lie in whether we are able to give input data into the algorithm that can fix those biases, and the larger data set that you're able to put back in, you'd be able to fix that issue sooner. I'll just also give an example of, a tool that Amazon developed several years ago in 2014 for recruitment based on a 10-year previous data on how the company made, hires. And they launched this in 2014 and they ran it through until 2017, only to realize that the data that was inputted pertained largely to male applicants, because those formed the larger set, within the data set. And it had developed a bias as a result against women applicants, and so much so that it downgraded even applicants who mentioned the word women in their application, right? So I think, and they tried to fix this in 2017, but they still couldn't modify or input data wide enough to correct all possible inaccuracies, and therefore they ultimately decided that it wasn't fit for use. So it'll boil down to what's fit for use.
Sorry. I know Anna is here, and I'm quite tempted to just invite Anna to make a comment. She just had a full-blown debate on this topic at the Untitled conference. Anna, would you like to say a few words? Would you? Anna, would you like to use the microphone?
For putting me on the spot. But I was on the first line and I was eagerly listening, and made me think of many things. First, I think that we always tend to think that arbitration is something special and that it has all sorts of features that make it so much better than the courts. What we should all be aware of is that the courts in many countries are working a lot on the introducing AI into their methods as tools to make sure that they become faster, that they get rid of this docket that, all these past cases that they haven't taken care of. And they use it, and they think of it as a tool to make it easier for them to render justice. So I think that's something we have to keep in mind. And there are all sorts of comments I was about to make, including on the last one about selecting arbitrators out of a list that is produced by AI as opposed to a list that is produced by a human being. I think the question is exactly the same, because when you present the list of arbitrators to your client, the client is going to say, oh, I don't want an arbitrator that has only 3 cases under his or her belt. I want someone who has already 50. And that is something that you can absolutely juggle, or you can set the criteria to have that kind of selection. So I'm not, as long as you consider it as a tool and not as what is going to replace all of us in the room, but it's a tool that is going to help us be more efficient. I think it's not even the future. I think it's already there. Thanks.
Thank you.
Can I just quickly paint a gloom and doom scenario? I think it won't replace us, but I think my fear is that it will relegate us to just being glorified underwriters of what the AI does. I think that is the real question.
Thank you.
Just one data point on that, Abhinav. McKinsey recently did a study on whether AI can replace lawyers on the assumption that if lawyers apply AI completely in all aspects of their work, even then McKinsey reckons that only 26% of what human beings, lawyers currently do can be replaced. So perhaps it's not such a bleak story.
Absolutely. I'm conscious that we are on a AAA-ICDR panel. And just like the AAA-ICDR rules, which always work and are timely and efficient, so should the panels be. And therefore, on that note, may I invite, firstly, let me thank the audience for being such a wonderful and patient audience with so many questions. And may I invite everybody to thank the wonderful panelists in the usual manner.
Well, we're not ending yet. There's still one last segment, and which is closing remarks from Judge Nageshwar Rao. Before that, I wanted to share with everyone an insightful thing that Esther Chawla, the director of AAA-ICDR in Singapore, actually came up with the title of this event using ChatGPT. So. So yes, AI permeates throughout everything here today. So Judge Rao is a former judge of the Supreme Court of India, and he's also a member of 39 Essex Chambers. He was enrolled in the Bar Council of Andhra Pradesh and practiced in Andhra Pradesh District Court, High Court, and later the Supreme Court. He was designated a senior advocate in year 2000, and in 2016, he became the 7th person elevated directly from the bar to the Supreme Court. Judge Rao, please.
Thank you. Thank you very much. Good evening, ladies and gentlemen. It has been really an interesting and fascinating discussion on almost every aspect of artificial intelligence in connection with arbitration and mediation. I don't think there's much for me to say, except a few comments on what have been spoken about by the panelists and some observations that were coming from the audience. Starting from the last comment made by Anna. I was the chairman of the Artificial Intelligence Committee, which was set up in the Supreme Court in 2019, when I was a serving judge, Justice Bobde. The first comment that he made when he set up this committee is that we'll use AI for improving efficiency, but AI is not going to replace the judges and the human mind. I think that that's what is exactly happening. Smita, you mentioned about British Columbia. In 2019, Estonia made an announcement that all disputes below 7,000 euros would be decided by AI judge. But in 2022, the government made a clarification saying, we're not going to do that. So it will be only the AI which would assist the judges, but AI is not going to decide cases. We have also read everywhere that China is having robots deciding matters. And I've read a statement made by the Chief Justice saying that even in Hangzhou, where small matters were being decided by AI is what we read, but he said they're only assisting human minds. So AI is not going to replace human judges. So if in law, if they are not replacing human judges, what's going to happen in arbitration? Let me deal with the point that Smita made about the predictability of arbitral awards. The young girl from the audience also was speaking about it. Algorithms feed on data. There was a study that was done by Katz in 2017 of all US Supreme Court judgments from 1816 to 2015, about 200 years. They did a study of about 28,000 judgments that were written by the Supreme Court and 243,000 opinions given by each judge of the court. On that basis, two questions were asked as to what would be the fate of a case that is brought before the Supreme Court and how many judges are going to vote in favor of deciding a matter which has come up from the Court of Appeal, the circuit courts there. So the artificial intelligence machine gave an answer saying that this is going to be the output, and 70% was the correct answer that was given. The same exercise was done for orders that were passed by the European Court of Human Rights. Even there, it was about 70%. But is the same possible for arbitrators? It's not possible because of what the young lady said. Where is the data? You have about 4,500 to 5,000 awards coming each year. You have civil law, you have common law, you have diverse subjects that are dealt with by arbitrators and arbitrations. It's very difficult for prediction of arbitral awards, not only because of this, it's also because arbitrators decide matters on complicated questions as an original suit. So there's no question of a review. So it might be very difficult for predictability, as both of you were talking about. And there was a discussion on bias. So when you're talking about bias, what is this bias? It all depends on the data that is fed in, assuming it's an investor-state arbitration. So on the basis of the material that is data that is fed in, the AI can decide in favor of an investor. If it's a buyer and seller, it might be biased. That was one of the concerns. There's another concern about opacity because it operates out of the black box. Nobody knows what is going to be the result. And the most important thing which has not been touched, which I would tell you, is this. Arbitrators have been innovative. Take the case of Dow Chemicals in 1982. The group company's doctrine was something which was a creation of an arbitral tribunal. Can AI do it? I have my own doubts. I don't think it can do it. You have intrapersonal intelligence. You also have interpersonal intelligence. And there's something called emotional intelligence. The AI doesn't have this emotional intelligence. Cases are decided by arbitrators on the basis of intuitive mind, which AI cannot. So I don't think for the present, we are not going to lose any employment. We are going to be there. So arbitrators need not be afraid of it, anything. The point that was talked about cross-examination as to whether AI can understand the feelings, the demeanor of a witness in case witnesses are being examined. I read a lecture that was given by Lord Leggett, who is a sitting judge of the UK Supreme Court. He took a different view from the majority where he said, is it always true that the judges decide matters on the basis of understanding the demeanor of a witness? He said, no, that might not be correct. But 80% of the people believe that judges are very intelligent. They're almost psychologists. They can read the witness. Witnesses can be very intelligent. Witnesses can also cheat. But he took that stand. So I'm not really sure about AI not being able to make out as to what would be the demeanor and what would be the basis of an award on the basis of demeanor. That being said about that, there was some talk about the legal regime as of now. The New York Convention doesn't either explicitly or implicitly prevent AI arbitrator. But all the countries which follow the model law, conceptual model law, have in their acts provisions which indicate that arbitrators can only be human. So for the present, I think we're all safe till some legislation is made. Using all the benefits of developed technology, science, ICT, etc., arbitrators definitely can benefit out of use of AI. But for the present, all the human arbitrators are there to stay, and we need not worry. We are in a very safe space. Thank you so much.
Thank you so much, Justice Rao. Well, thank you so much, everyone. We've come to the end of the program. I'd like to take this opportunity to thank all the speakers again for an insightful conversation on AI, and also the Asia CMC team, Michael Lee, Esther Chawla, and Pamela Ishan. So thank you very much, everyone. Have a good evening.